National figures show consumer debt at an all-time high. And as the economy slows, many Vermonters are having trouble keeping up with some of their obligations. So much so that they're beginning to deal with the very difficult question of whether or not they need to consider filing for personal bankruptcy. Michelle Kainen is a member of the Vermont Bar Association. She is the chairperson for the bankruptcy law section. Michelle has the opportunity to visit with Vermonters on an almost daily basis who are struggling with this difficult decision whether or not they should file for bankruptcy. So thank you so much for being here.
Thank you for having me.
You know, I think probably the biggest question people have as they come to see you is probably, if I declare bankruptcy, will it really wipe out all my debts?
Credit card bills, medical bills, utility bills, things of that nature are generally dischargeable in bankruptcy. The types of debts that would not be dischargeable are alimony, child support, most taxes, and for the most part, student loans.
And some people are very surprised to hear that about the student loans.
They are. Many of my younger clients are sort of driven to the point of financial devastation by their student loan payments. They've started to support themselves, living on their credit cards, and then reach a point where they can no longer afford the credit card payments and the student loan payments, and then find themselves in my office.
Difficult situation.
It is.
You know, another thought that I think people have about bankruptcy is that if they file for bankruptcy, everything they own will be taken away from them. And again, it's not necessarily true.
That is absolutely not true. Under both federal and state law, there are limits to what a person can keep in terms of personal property and real estate and not have to repay any of their debts. Most of my clients find these limits to be quite adequate, and rarely does a client lose something in bankruptcy that they had hoped to keep. It's important to remember, though, that if you owe money on a house or a car and you want to keep those things through bankruptcy, that you would need to continue to make the payments despite the bankruptcy.
So you need to be thinking ahead about what you can afford.
Absolutely. Budgeting is a big part of this process.
What are the different types of personal bankruptcy?
For consumers, we generally look to two types of bankruptcy, Chapter 7 and Chapter 13. A Chapter 7 will get rid of most of the types of debts that we talked about earlier and is generally available to consumers that are not high wage earners and do not have substantial assets.
Mm-hmm. It is one of the most common of the two.
Absolutely.
And the other one would be Chapter 13.
Chapter 13, yes. Chapter 13 is a reorganization, and generally people would file a Chapter 13 to try and save a car from repossession or a home from foreclosure. You enter into a repayment plan for a period of 3 to 5 years and generally repay a percentage of your debt, but rarely all of your debt through a Chapter 13.
It must be a tremendous relief to know that you can negotiate and do that.
Absolutely.
If someone is considering declaring bankruptcy, if they declare bankruptcy and they're married, would their spouse also have to declare bankruptcy?
Absolutely not. And this comes up quite often. It's important to remember that while one spouse absolutely can file bankruptcy alone, if both spouses owe a debt together and only one spouse files bankruptcy, the spouse who did not file will solely remain responsible for that former joint debt, all on their own going forward. So it's something to consider.
Is it expensive to file for bankruptcy?
Well, there are court filing fees. The fee for a Chapter 7 at this point is $299. A Chapter 13 is $274. There are credit counseling fees that range from $35 to $50 a session, and there are 2 sessions required. In addition, and the bulk of the cost really is the attorney's fees. Those vary widely from attorney to attorney and depending on the complexity of a client's particular situation. Most attorneys in Vermont will offer a free consultation so that they can evaluate your situation and determine the fee that they believe is appropriate in your particular case. It's important to remember that before hiring an attorney that you obtain a written fee agreement that describes what the attorney's fees include and what they will not include.
It's good to have that expectation.
Absolutely.
Thank you so much.
Thank you for having me.